is with us. He's working overtime because this is the busy season for Supreme Court rulings. Greg Willard is a professor at St. Louis University Law School and our KTRS Legal Analyst. Good morning, Greg Willard.
Good morning, McGraw.
All right, let's first get to what happened Friday in a 5-4 decision where conservative John Roberts, say it ain't so, joined with the liberal wing of the court.
He did. He joined, as you say, McGraw, with the four so-called liberal justices in a 5-4 decision, and the four so-called conservative justices went against him in the five, and he wrote the opinion for himself and the four so-called liberal justices.
All right. So what did they decide?
It was a fascinating case, McGraw, particularly in this ever-growing age of digital technology. Let's see if we can set the stage. A Mr. Carpenter up in Detroit, Michigan, he and his merry band of pals were going around committing armed robberies at Radio Shack stores.
Right.
For weeks and weeks and weeks. The police went to his cell phone provider and got 127 days of his cell phone records, and specifically what's called cell site location information. A lot of our listeners may not realize it, McGraw, but there is a record created every day for every cell phone as to where that cell phone is all day. So the law enforcement authorities got Mr. Carpenter's cell phone records for 127 days, triangulated his location, and guess what? They matched up to the Radio Shacks that had been stuck up. So he's prosecuted, convicted, and sentenced to 116 years in the penitentiary. He appeals his conviction to the Supreme Court, and Friday morning, Chief Justice Roberts and his four fellow justices threw out the conviction. And they ruled that the acquisition of Mr. Carpenter's 127-day cell phone location records, that was an unconstitutional search under the Fourth Amendment to the Constitution, and they vacated his conviction. Now, there is a part of the body politic that will say, great, standing up for civil liberties.
Right.
There's another part of the body politic that says, here we go again, letting criminals off on technicalities.
Right.
And so there's the normal hue and cry. I would suggest a little different perspective, one that we've shared on the air before. And that is, from time to time, the Supreme Court goes off the rails.
Okay.
And not perhaps in a fundamental way, but they go off the rails. And then what happens is when you try to catch up, it's like those old Buster Keaton movies when he tries to catch up with the train. Well, that's basically at play here. And what I mean by that, McGraw, is this. In 1967, the Supreme Court said that our Fourth Amendment, yours and mine and our listeners, our Fourth Amendment protections against searches and seizures, what that covers is those things where we have a reasonable expectation of privacy. Now, with homage to the late Supreme Court Justice Scalia, who would remind us, McGraw, we can sit here all day, and you will not see the phrase in the Fourth Amendment, reasonable expectation of privacy. It's not there. But the Supreme Court in 1967 in the Katz case somehow found it.
Okay.
Well, in the 70s, then the Supreme Court said, well, wait a second. With your bank records, your bank account records, and your phone records of who you called, well, you can't have a reasonable expectation of privacy because those are in the hands of a third party. So they tried to get it back on the rails, and they said, well, the third-party doctrine will allow law enforcement to find out who you called and your bank transactions.
So they don't need a warrant to check my bank records or who I called because AT&T is a third party.
Correct. And so you're, even though it may be your effects, to use the language of the Fourth Amendment, the third-party doctrine. And so everybody said, well, okay, we get it. Law enforcement now for 40 years said, we get it. If it's in the hands of a third party, it's an exception to this 1967 rule until Friday morning last. And the Supreme Court said 5-4, well, if you had a reasonable expectation of privacy as to records that were held by a third party, then those can't be acquired without a subpoena. And oh, by the way, if those records are held for at least 7 days, if there's 7 days worth of records, then that's a line. We won't tell you what the line is otherwise, but that's a line. So law enforcement, go get a warrant.
So now this is interesting, but in practical terms, that going forward, that police department could say, boy, we think this is the guy. Let's go to a judge and get these records courtesy of a warrant. They can do that, right?
They can do it, but I think if we had an FBI agent or a St. Louis County detective sitting with us here in the studio, they would say, a lot of times, McGraw, we don't know who the guy is.
I see. So they went and they called the records and then narrowed it down from the records.
Well, a lot of times that's what they have to do.
Right.
And so they do a tower dump, it's called. And so what law enforcement would say is this is really going to restrict our ability to get the bad guys if in order to get these individualized records, we've got to go get a search warrant, because the standard to get a search warrant is significantly higher than the standard it would take normally for just a subpoena. All
right, so what's going on with Judge Roberts? Is he caving? What's going on here?
Well, I think it's hard to psychoanalyze a Supreme Court justice, but I think what he's doing is, as we've seen him do before, is he is looking out for the public perception of the integrity of the court. And we saw it in the gerrymandering case recently. We saw it in the Obamacare decision, in that he feels, as the Chief Justice, that it is incumbent upon him to do all that he can to sustain the public perception of the court. And so I think what he felt in this case is it was important for the court to make a statement as to modern technology and the pervasiveness of modern technology, and he joined with the liberals.
But that being said, and psychoanalyzing Supreme Court justices, don't kid yourself. You guys love doing this all day long. We don't like to do it, but let me psychoanalyze a guy. But that's not the role of a Supreme Court justice, right? It should be on the merits of the case. And the fact that if this is the case, that he's looking at the perception of the court and how people are going to perceive it. Hey, you know what? My case is in front of the guy. It should be dealt with on the merits of the case.
Well, I think you make a textbook statement vis-a-vis the Obamacare decision, where he was the fifth vote.
Right.
And he said, well, that thing called a penalty in the statute,
right,
that's not a penalty. I'm going to call it a tax, and therefore the Obamacare is constitutional.
Right.
And a lot of commentators, law professors, and others said exactly what you just said then, that that's not the place for a Supreme Court justice, much less the chief, to be calling balls and strikes that way.
Right.
But I think the reality is that he, and he's not the first, but he feels an obligation to decide cases and to look out for the public perception of the court. And I think that played a role in him writing the opinion in this Carpenter case last Friday.
Yeah.
And we may see it again this morning, McGraw.
Okay, so now what's the term ends, the end of the month, right?
The term ends at the end of the month. They're going to convene in about an hour, and they are going to release some opinions today. One of those opinions may be the travel ban, the President Trump's travel ban, and it will be fascinating to see how the court stacks up there.
Right.
There's another case that in this area and the rest of the country won't get much play, but in the southeast United States will get enormous play, McGraw, and that is the state of Florida and the state of Georgia have sued one another in the Supreme Court, and it's over water rights to the Chattahoochee River. If Florida prevails, it will have a devastating effect on Atlanta, the likes of which probably hasn't been seen since General Sherman came to town. So that one will be decided perhaps this morning, perhaps this week.
Water rights, don't kid yourself. That Missouri River runs through, and that Mississippi River runs through a whole lot of states.
A whole lot of states, and whether it's the Mississippi, the Rio Grande de Colorado, or in this case Chattahoochee, it is a big deal. And in this lawsuit that the Supreme Court is about to decide, the economic impact, as I say, on Atlanta, in theory, could be as great as when General Sherman came to town.
You know what I mean? Nebraska could decide to, dam up the Missouri River, and who cares what happens downriver, right? I mean, that's an extreme case. But the point is, though, whose rights, who has rights to the water?
Well, and you hit it right on the head, and that is one of the core issues in the Florida-Georgia case is that with the Chattahoochee River, it has been dammed in Georgia, and then Georgia is taking, as we say, ginormous amounts of water for the Atlanta metropolitan area.
Right.
And Florida is saying, wait a second, that's violating our downstream rights in the Chattahoochee River. And just like whether it's Nebraska or Nevada, or in this case, Florida, it is a big deal, and we will hear perhaps today, but certainly this week.
All right, so you have the travel ban, you've got that. Anything else that we should pay attention to?
I think those are the biggies, McGraw. The travel ban. There are a few others, but I think the ones that will get the clatter will be primarily the travel ban. There's a gerrymandering case. We talked on the air. Another gerrymandering case. This one's out of Texas.
All right.
But it was more of a racial gerrymandering rather than the partisan gerrymandering coming out of Wisconsin. So that may get a little clatter, but I think the travel ban is the one we should fasten our seatbelts.
The travel ban, they have a flair for the dramatic. That will probably be the last one, won't it?
I think that would be a fair expectation. And again, the fact that it has taken this long and it goes up to the 11th hour of the term tells you that it won't be 9-0. It will be like we saw with the Carpenter case last week. There were 5 opinions running 120 pages. So I think we can expect a similar divergence with the travel ban, McGraw.
Never a dull moment. Keep your cell phone on. Greg Willard, professor at St. Louis University Law School, and our legal analyst. Greg Willard, thanks for coming in.